My name is Brian Burdick. I'm a lawyer with Barnes Thornburg here in Indianapolis, representing the Indiana Hospital Association. And thank you, Senator Baldwin, for filing this bill, introducing this bill. I'm not going to repeat some of the great points that were made here, but I might provide some context and color around them for everybody. First of all, the Hospital Association values our independent physician partners incredibly. It's a huge issue in rural areas. Senator Randolph, to kind of getting your mind around what's happening here. An anesthesiology group may serve 5 or 6 counties in more rural areas. They're in maybe Indianapolis, Indiana, they may have a group that's employed by a large system. But so that's the dichotomy that exists out there. But both are very important to our healthcare ecosystem in the state. And this issue is of particular importance to rural healthcare in Indiana. What brought this about was in October, Anthem sent letters for starting the renewal discussion with hospitals for the upcoming year, starting January 1 this year, for their agreements. And it said, if you use a non-participating provider, a physician who's not an Anthem provider in your hospital, we are going to deduct 10% from you, the hospital's reimbursement. This is to the enforcer point that I think your term, Senator Baldwin, that you raised. And let's talk about why that happens. Okay, so at the federal level, you heard about this No Surprises Act, a bill that was negotiated heavily at the federal government. You've heard it a lot in this committee and in health committees if you're on them, but it's designed to prevent surprise billing to occur for our citizens in the state when they have operations and the like procedures at hospitals. And so what this did is it said, hey, look, if you can't come to an agreement with a non-network provider for what they serve, try to negotiate it out. And if you can't come to an agreement, we'll go to an independent dispute resolution. It's like a baseball arbitration. So the doctor would submit a number that says, I think I deserve this. Anthem submits a number and they say, no, we think you deserve this. And then the arbitrator decides what's fair of the two. The answer may actually be somewhere on the continuum between the two, but this is how the process works. Anthem has been losing, as I understand, 85 to 90% of the time at the federal government. Through some of our research, I understand, but they'll be here to speak, and they didn't show for 30% of them, et cetera. But what happens is really, this bill should bring down costs. The way you want to bring down costs, and to Senator Gaskell, you have this good questions trying to understand the cost aspect. If Anthem wins more, my cost, I'm the chair of our Pensions and Benefits Committee at the law firm, so I deal with this, we're self-insured. If Anthem wins more at the independent dispute resolution, we don't pay this, we pay this. So the issue is about being fair on reimbursement. Pay a little more, offer a little more. At some point, you're closer to what the independent arbitrator says is an appropriate fee than maybe what the physician is offering. That would bring down healthcare costs. The fact is, you have this duopolist position that's occurred. And I would say the Federal Department of Justice has done wrong by us by approving M&A activity in the health insurer space over the course of the last dozen years. The result is in Indiana, you heard the market power here, Anthem and United are probably 75 to 80%, of the insurance provided in the state, whether it be fully insured or as a TPA. And their fiduciary duty is not to you as a patient or to anybody other than by law, their shareholder. And so that is to maximize return for shareholders. So when you used to have a competitive market, 30 participants chasing our work at the firm, great customer service and fair reimbursement would cause people to be in network, be great service for our employees. It would be great. Hello, Senator Freeman.
I'm back to serve my sentence.
Thank you. So what happens is, you would have an efficient market, a bunch of participants where you would have a fair negotiation, you have fair rates, but that market has collapsed. So I don't know how many market participants it takes to have an efficient market, 6, 8, 10 insurers where you cause competition, but the indicia behavior, what it looks like when you don't. And that's what you've seen here. You've got a situation where, in this case, Anthem says, we're going to pay you something so low, and there's an interest in being a network because you get paid directly, et cetera, something so low that I'd rather take my chances negotiating and going to an independent dispute resolution to see if I can stay in business. That's just purely because they have the market power to do it. The physician groups in this case don't have a choice. And so the marketplace would tell you, the independent dispute resolution process, that what's occurring is Anthem is offering too low of a fee to the physicians, as you've heard from their practices before. So they're losing 80%, 85% of the time at the independent dispute resolution process. So that runs up cost. If they were be more reasonable in their reimbursement, you'd probably have more doctors going in network. They would win more at the IDR. It would bring healthcare costs down. At the end of the day, as a hospital, so I just want to put some context around the earlier discussion about why we're here. At the end of the day, from a hospital association perspective, we don't want to be the enforcer. We're not a party to this to try to force us by saying we're going to deduct money from your bill if somebody who's not in network provides a service at your facility. Really is just an effort to coerce or force us to try to pressure these independent physicians to go in network with Anthem in this case. That's not our fight, but more importantly, in rural parts of the state, et cetera, it's just not what reality is. So we value these independent physician groups, and we want to make sure that they have viability in the future. So thank you for doing this.
A couple clarifications. When you were talking about that IDR process and the baseball style of arbitration, then that arbitrator has to select one or the other number, right? It's not
Correct.
Somewhere in between.
That's the issue, and they choose. So you got to figure that the arbitrator, trying to be fair, what's the fair price here, is going to choose the one closer to whatever they independently think would be a fair price. So my point being, and thank you, Senator Baldwin, for the question, is Anthem, if you want a lower cost for healthcare, offer a little more, because your offer presently is too low, and so they're choosing the one that the physician group is offering. And so we could be paying more, but if Anthem wins more, we're going to be paying less. So I think it's about being equitable with the independent physicians who are providing the service.
Thank you for that. And I, as I look at this and I'm trying to continue to understand, I've spoken with Anthem. They've given me some strong information about the CMS process, the IDR process that CMS controls. And while I can sympathize and probably agree with much of their plight, I'm having a hard time understanding that that's a revenue problem for them. I'm having a hard time with this as the answer and the nexus between the two, and it feels and I'm trying to explore how an organization with this much market power in the state of Indiana wouldn't be considered to be coercive in their practices, or having a monopsony, or vertically excluding people through the hospital. Talk a little bit about maybe how close are we to antitrust, or is this more of a deceptive insurance practice?
I mean, I think these kind of things I felt for a while, and I've been in front of these various committees talking about EMS reimbursement and the like. What's happened with the M&A activity, merger and acquisition activity in the health insurer space in the last dozen years, really since the Affordable Care Act, it created single payer by another name. Used to have a ton of health insurers. Well, Department of Justice kind of, in my opinion, didn't enforce the Antitrust Act and just made, 3.5 or 4.5 in the country. It's Anthem, United, Humana, Aetna, there's Cigna, there's a couple out there. In our state, we only really have 2 that dominate the market. Well, that market's collapsed. So what happens when that occurs? If a bill used to be $1,000, perhaps they pay $800. But now they don't have to compete to get a doctor or a hospital in network, or to sign up Barnes Thornburg as a client to provide customer service, and be the TPA on our self-insured plan. So when you don't have to compete, the result is, and remember, before, I should go back point, their fiduciary duty is to their shareholders to maximize return. Competing against 30 people for our work is aligned, signing up businesses, signing up docs, signing up hospitals in their network. That's aligned with maximizing shareholder return when they had to compete. Now they don't really have to compete. So what happens? We have no place to go. Their rates go down to reimbursement. I'm making these numbers up for sake of the explanation here. If there's a $1,000 bill, they used to reimburse $800. Now they reimburse $300. Why? Because they can. Where are you going to go? There's only 2 places you can go. And the other guys come in and they're a nickel apart from you. So to me, there was a failure of the enforcement of the antitrust laws. That's really why you have them, to maintain an efficient market where you'd stay up and people are competing. When they collapse, you see the indicia of behavior. And so I'm not going to accuse them of that, but I think these are the kinds of behaviors that you see in the marketplace. They're living up to their legal duty, maximizing shareholder return. It's just not aligned with patient, physician, doctor getting healthy in this area. Theirs is diametrically opposed to that at this juncture. And I want to say, too, I want to compliment David Ober from Anthem. I think David may testify or something later, but he's been great to talk to. He put together a meeting with all of us to chat through what the issues they're facing, and I understand the issues that they're facing. I don't think they're in the state. They've got some issues in Georgia, some other places. They're talking about private equity and some other stuff may be involved, but there's not really what's happening here. I think it's maybe a corporate initiative. It doesn't have a place here in Indiana. But yes, it's the coercive activity that they're trying to just coerce us, not a party to that, to force people into their network.
And I can sympathize with the failures of the IDR process and what that might be doing to their revenue. And they're going to argue network adequacy, cost containment, administrative efficiency, those kinds of things. I get that. I'm just having a hard time how struggling with that allows you to go and do this, which feels really coercive to me. But I'm trying to listen and understand. What other questions do we have to Mr. Burdick? Senator Krasko.
Thank you, Mr. Chairman. Hi. Thanks for being here. I think my question is just going to be kind of, it'll start simple and then I'm sure it'll get complicated. My bottom line is trying to understand if we go through this process and the arbitrator chooses a particular dollar amount that is likely going to be higher than what the Anthem reimbursement rate is, who ultimately bears that cost? Where does, if there's going to be an increase in what the insurance is going to be paying, somebody's got to pay for it. Can you kind of
Because if you're a fully
flesh that
insured
out?
plan, the insurer would pay. If you're self-insured like Barnes and Thornburg would pay.
So how does that then translate to the consumer ultimately?
Yeah, so it's lowering costs in the marketplace. If you have to go to independent dispute resolution, again, it's sort of, you're choosing your 2 points. They're offering a number consistently so low that they're losing 85 to 90% of the time by an independent arbitrator here. So they're choosing this number. So the result of choosing this number all the time, the higher number, is more for Barnes and Thornburg to pay. I would say, Anthem, offer a little more till you start winning these cases. That lowers what Barnes and Thornburg pays for that claim. It just seems that it's probably gone a bridge too far. And so, you know, they're losing in the eyes of the independent person that you couldn't come to through a negotiation, some agreement on, will say, hey, we'll push all the chips in and you pick one or the other. So I think they just probably need to be more equitable in what they're offering until the point they start winning more. That helps lower costs for us as employers.
And just to make sure that I kind of carry out the thought all the way, as if it's going to increase the cost for employers, then ultimately that'll affect potentially the premium if I were working at Barnes and Thornburg.
Correct.
On whatever my monthly or whatever basis would be, right?
Correct. And we're so focused at the Hospital Association on, you know, average commercial rate. We've heard the legislature over the last several years. 1004 was a big step in that direction. We're trying to do things to help bring this down. In this circumstance, Anthem winning more would help with that, you know, by some factor of something, but it's directionally correct. And for us, just being able to provide services throughout the state with our various members, you know, we need independent physician groups to be able to do this. These specialty groups, as you heard before, anesthesiology, radiology, oncology, they're not employed physician groups with a hospital system in these places. They serve 5 or 6 counties and, you know.
I don't know if you would know the answer to this question, but I'm trying to think about, again, going back to the impact that it would have on me as a consumer ultimately. Do you know if throughout this arbitration process, the independent group prices for the services are inflated, to use, for lack of a better word, with the idea that we're going to come to something that's lower? My concern is that arbitration process actually resulting in a more accurate cost for the service?
Yeah, you know, we're not a party to it because it's a physician. It's probably a good question for those folks. I can't tell you if it's inflated or not. I think the way the process would work, though, by taking evidence and thinking about it, you'd say, an independent arbitrator would say, what I think is the fair amount to be paid. That could be somewhere in the middle of these two offers. And I imagine they choose the one closer to what they've determined to be fair. But I don't have specificity to that.
Any further questions? Oh, Senator Randolph.
Thank you, Mr. Chair. I'm just trying, just a couple of areas. One, I want to piggyback on this arbitration. When does that kick in? when is an arbitrator there? Is there a contract from the beginning or an understanding in the industry that if in fact there's a dispute between an outer network and in-network arbitrator, how does that kick in?
My understanding, Senator Randolph, is the services are provided, an out-of-network provider and Anthem have had some conversation about what Anthem has offered to pay them. They try to negotiate a fair payment that both would consider to be fair. If that fails, the physician in this case would say, we'll go to independent dispute resolution because we're not coming to an agreement, or it's too low in my opinion, and they take their chances there. That's the process to get there.
But is that a standard within the industry that automatically you have a right to request arbitration if you got a dispute? Or is that because normally when I hear arbitrator, I think about an agreement between the parties.
Right.
If you got a dispute, we have an option to go to arbitration as opposed to going to court. So how does it kick in terms of the medical industry?
Yeah.
I mean, how does it come about? It just come about. There has to be some kind of understanding between the parties or the industries that if we get to dispute, arbitration is the alternative. I mean, how does that develop?
Yeah, there's a very prescriptive process that was outlined in the Federal No Surprises Act to get to this conclusion. So that's just the process. It's outlined in federal law.
So federal law says you have to go through that process.
Yeah, you try to negotiate it out. We don't want people going to IDR. You know, you'd rather have parties, as you well know from your, negotiate things out. But if they can't, there's an end to it.
Okay, that explains that part in terms of how it's initiated, how it started onto the scene. But if in fact you've got a carrier, you've got an outer network provider at that point in time, you've got a dispute, I would think that, first of all, I guess my question is, compound really. Based upon your experience, is normally the carrier, if you got a dispute where you got an arbitration, do they normally win most of the time or they normally lose most of the time?
My understanding is at the federal level, in this No Surprises Act independent dispute resolution process, that Anthem in this case has been losing around 85% of the time.
They win 85%?
Losing about 85% of the time. And so that's the genesis of why the letter came to the hospitals to say, we want you to sort of be the enforcer, as Senator Baldwin mentioned, to force doctors into our network. And because they're not winning at the independent dispute resolution. I would argue that's somebody independent suggesting that what's being offered is not really equitable. And so they're choosing this number, when really offer some more and you'll find out you start winning more and you'll know you've hit the sweet spot. I mean, you understand this from your time, and yeah.
I guess my experience has been in terms of when I dealt with these arbitration issues, if in fact they start losing, then they start being a little bit more sensitive toward what they're offering and offer a little bit more by losing, because if they lose, that means they're losing more money. But if they start winning at that point in time, it might allow them at that point to maintain their practices at that point. So I'm just trying to understand that the procedure and the logic in terms of that, the reasonability of that and everything in terms of that. So that's one thing I'm trying to gather in my mind.
Yeah.
The other thing too is you indicated that when you talk about the antitrust issue, if in fact that, in your opinion, if in fact there had been a much more forceful enforcement of that in Indiana, we'd have more than 2 carriers dominating the market?
Yeah, I think nationally it's probably an issue, but yeah, I think at the federal level, the Department of Justice and the Federal Trade Commission, who reviews merger and acquisition activity, have to make some findings about, you'll see this in banks where they force people to, shed deposits and stuff because you have too much concentration in the market. The concentration you heard today of Anthem and United with what the power they have in Indiana is a lot. I'm not accusing them of antitrust activity here, but I'm saying the kind of practices that are being engaged in are sort of the indicia of outsized market position that you can sort of do what you want. In this case, I couldn't be more aligned with what you said at the beginning. If they were losing all the time, most of the time, start offering a little more, be sensitive to it. Then you win. That's a win for everybody. Instead of choosing that, what they've chosen is to send letters to hospitals that say, we're going to penalize you 10% to force people in network. I mean, my solution is exactly what you said articulately there in the first part.
And so this bill would help alleviate that situation.
Yes, yes. I think it puts it back in the market's hands.
And on the first part, the part dealing with the penalty part, we dealt with that and everything. It all relates indirectly to that as well in terms of that.
I think Senator Ball was going to talk about that. Instead of the penalty, it'd be a deceptive practice, but an enforcement mechanism to stop the behavior.
Yeah, I have an amendment we're gonna do here in a bit, but I want to make sure everybody understands, and maybe it was a form of this, I'll phrase this as a form of question to you, Mr. Burdick. This CMS process, this independent dispute resolution, we can do nothing about that here in the state of Indiana. That's a federal process, is it not?
Correct.
All right. What we can do is we can classify a certain activity as a deceptive insurance practice if it's violated here. I have an amendment that changes my penalty to the statement that it's a deceptive insurance practice, and then it can be regulated by the Department of Insurance a little bit more closely and more, rationally, contextually on a case-by-case basis. But at the heart of it, regardless of what's happening at the federal level with the CMS IDR process, this policy that Anthem has instituted, hospitals, you represent hospitals, can they realistically drop Anthem with its current market share?
No.
So Anthem is exerting market power over hospitals in the state of Indiana with this practice.
That is our view. Yes.
And would this not materially force hospitals to terminate or discipline their physician groups?
Yeah, I think it would. The result of this policy would be such that we'd probably strongly encourage independent physicians groups to get into network because they're penalizing us, and we're not a party to that contract between the physician group and the insurance company.
And if Anthem was doing this directly to physicians, it'd be much more close to antitrust.
I mean, yeah, they could negotiate with physicians and maybe pay a better rate to them. There's a reason they're not in
Right.
network, right? That what's being offered is maybe too low for the folks that make that decision.
But this policy, would it not substitute for individual physician negotiations?
Yeah, for sure, it would take hospitals out of it would encourage or allow the independent physician groups to remain independent, I believe.
Yeah, and we're throwing around the antitrust word. I don't know if that's fair or not, but they're certainly in the gray zone for it. And what they're not in the gray zone for, from my appearance, is deceptive insurance practices. And so I'm making that as a statement, not a question there.
It's not market behavior you would see 15 years ago when you had more players in the market. That's all. So,
okay. Any further questions, Mr. Burdick? Mr. Freeman is not wanting me to have one, but I'm going to let you have one anyway, Senator Randolph.
Yeah. So in terms of, it would be to an advantage of the hospital association to have independent people out of the network, because I think at that point, it allowed them to be in a better bargaining position with the carrier.
it's really more about access to care. Independent physician groups are important because they serve, particularly in rural areas, multiple counties, the specialty areas. Think of it different than maybe one of the big systems here in Ascension or IU Health. They have some physician-owned groups, but they have so much volume there that they can stay busy 100% at that facility. In other parts of the state, including in Indianapolis, but other parts of the state, you don't have that, and they serve multiple areas. So for us to be able to have services at small critical access hospitals and the like, we need to have independent physician groups available.
But access would be one of the advantages, but at the same time, it still would allow them to be in a better bargaining position with carriers by knowing that they have the option to deal with out-of-network.
Sure. Yeah.
Right. Okay.
And this would
Thank you, Mr.
be
Chairman.
keenly more impactful in the rural areas where we have healthcare
Yes.
deserts, would it not?
Yes.
Yeah. Okay, thank you for your testimony
you.
today, Mr. Burdick.